So thanks for joining this webinar. So we're presenting this as a joint event between Berwins Digital and Page White and Farrer. So we are both based for our Leeds operations at Platform. So we're also doing this in conjunction with Bruntwood SciTech, and thanks very much for them for assisting in promoting this. So so Page White and Farrer, London-based, but opened their Leeds operation just before lockdown happened. Literally, they are across the corridor from us at Platform, so welcome to Leeds, and that should work really well. We're going to be talking today about various aspects of intellectual property and how those work to improve the value of your business, elements that Berwins do, elements that Page White and Farrer do, and so this should give you a really good overall understanding of the area. So we'll be starting from Berwin's end as myself and Sam Crich, who works with me on digital side of things, and for Page White and Farrer, Tom Woodhouse and Virginia Driver, and they'll introduce themselves when they come on. So just so on the question of IP, so understanding intellectual property in the creative and tech sectors is vital. There's so much value in that, and you'll get a good idea from what we discussed today, what that is, what those rights are, and what you can do with those. For myself, I've been involved in technology businesses or advising technology businesses for some 20 years, I think. Head of digital law at Berwins Digital, and we also deal with sale of businesses with IP assets, with acquisitions of code and various issues of that sort. So this is very much where our interest is. So what are intellectual property rights? There are a number of different rights. There are patents, which specifically Page White and Farrer will talk about with some real expertise there. Copyright, which we'll talk about. Design right, which we won't really be dealing with today. Trademarks, which we will discuss, partly because it's something that's just of interest to everybody, but adds terrific value. Database right, which again we won't be dealing with, and generally confidential information can also be an intellectual property right. So as I say, we'll mainly be looking at copyright and trademarks. Page White and Farrer mainly looking at patents. It's always useful to see some real examples of things that have gone right, things that have gone wrong. Some examples that we've got. One is a business intelligence company that we dealt with a few years ago. They were operating using an API which they didn't have rights to from a major American corporation. They were doing very well, but the US corporation found out what they were doing. We got the heaviest of heavyweight legal letter from their lawyers. And then at a certain point, the American company said, "Oh, this is really interesting what you're doing." So various other options appeared, down to a point where they could either have been closed down and had a very hefty legal suit, or be paid out. So we'll see more about that. Another case was a domiciliary care company, not a tech company at all, of course, but they use rota software, so they know which carers are going to visit which people's houses and what care is needed. They'd had their own software developed by a third party, no contract covering that, so issues arose about whose software that really was. And then another one, so Tour de France is on as we speak. When that was in Yorkshire, everybody was wanting to use Tour de France trademarks and so on. Tour de France trademark is hugely valuable. A license to use it is very expensive, and there was a campsite on its route that basically used their trademark, didn't have a license to do so, and in the week before the race, they received another heavyweight letter asking them to pay up or face the consequences. And that was in the week before, when they had people booked to be there on the site. So the main kind of issues are to consider what rights are applicable, whether you've actually got the rights to use those. And you need to know that before there is value. So who owns the rights? And that might not be who you think it is. So we'll talk about that. And one of the key issues on IP rights generally is what you can protect is the expression of an idea, but not the idea itself. So the idea might be capable of being rendered in a number of different ways. So it's actually the expression of the idea which you protect. So we'll talk about copyright then. So copyright in software is one of the key rights. Say Page, White and Farrow will talk about patents when it comes to software. We'll talk about copyright. And we deal substantially with licensing of the copyright in software. So that's a big part of the work that Berwins Digital do. So in software, it might be code, it might be sound, it might be words, it might be pictures, and you can imagine that in certain types of software, it's all of those things. So if you think about games, something of that sort, there'll be music, there'll be sound, there'll be graphics, there'll be all sorts of things. So you have to ensure that those are original, that they're not copied. Copyright is not registrable, so there isn't a central register in the way that there is for trademarks and for patents. Copyright arises automatically, so the fact of creating something that's original creatively gives you copyright, and it lasts in most cases for 70 years from the date of creation of the work. It's actually the end of the calendar year in which the work's created, rather than having to identify the actual day. So in software, it's one of the principal rights, but there are other rights that are really important as well. So in terms of licensing software, so as I say, that's a key thing that we've been involved in. So I mentioned APIs in relation to the business intelligence company. There has been running for the last 10 years, and there is now at the US Supreme Court a massive case between Google and Oracle, and that arises out of the copying in a certain way by Google of an API, an application programming interface, to Java. Java is owned by Oracle, originally developed by Sun Microsystems, and it allows programs to speak to each other essentially and fetch information from each other. Google were seeking to develop Android at pace because Apple had launched the iPhone, and they thought that they had accessed the Oracle the Java API in a way that they were permitted to do so. Oracle think that they didn't, and so there are massive issues for the software industry around this, and so this is going on, and it really comes down to fundamental issues about the right to develop programs and the right to protect proprietary rights. Generally, the IP is in the object code, so that's in the ones and zeros that source code is compiled to, and the key thing is to protect the source code, so that's the human readable code, and to regulate the release of source code if it needs to be released in the case of emergency. So that will be under an escrow agreement. So again, these are the kind of things that we deal with on a day-to-day basis. A lot of developers will use open source code, and so I'm going to pass over to my colleague Sam, who will talk about open source.
Hi there. So, open source software. I mean, just as a high-level introduction, if you're not aware of open source, it's software which exists and is freely available for people to use. It's not free in the sense that you don't pay for it or that you can't charge money for it. It's free in the sense that it's open. So Libre is a better word to use to conceptualize that. So we're talking about large repositories. GitHub is an example, where people are effectively contributing to the commons and trying to further with the general aim of benefiting the wider society from sharing code, not reinventing the wheel every time, speeding up projects, making it more cheap, effective, and efficient to develop new software products which are going to solve other problems, or solving the same problem in a different area and not having to go through the long drawn out development process of creating bespoke code. Obviously that sounds very nice, but when you're trying to develop value, you don't necessarily want to have to give away what you've developed for free, which is sometimes the requirement of this. So here we go. I think we've had a little, let's try this, shall we? There we go. Right, so we've talked about copyright as a way of protecting rights. So if you think about copyright as effectively protecting almost the confidentiality in the code that you've developed, you don't want people to share it for free. You don't want people to make it available to everybody. Effectively, you're trying to get them to keep it secret, and you want people to come to you for a license for that in order to use it so that you can continue to make money. Copyleft, on the other hand, is ensuring that that code, when it's used, is not kept confidential, so that it's made free and open Libre for other people to use. So the principle of copyleft and in the versus copyright, you will come across restrictive versus permissive licensing. Now, the key thing to check is which license applies to which module you've used. And as you'll know, you might have hundreds of modules within a software package that you've developed. And when you come to sell your business or try and sell or license that to a customer, they're potentially going to ask these questions. Now, in the past, according to Gartner studies, you know, up to 90% of software projects have used some element of open source. But do people, the business stakeholders, realize that open source is being used? 60% of the time, 80% of the time, no, they don't, and they don't ask any questions. This is important to consider when it comes to the valuation of software companies, which, as we all know, it's very hard to value how much a piece of software is worth. And this really can introduce a lot of uncertainty that can be used to attack the value in your business if you are trying to sell it. And that's something that we have come across and experienced in the past as part of due diligence. So I've got here a reference to the GPL v2, which if you see that, generally have a little look into it, because it can be a problem. It's got what is referred to in the industry as a viral nature to it. So that means that it attaches to, and the wording from the GPL license is as broad as it sounds. It's if you use the whole or part of some GPL v2 license code in the whole or part of the whole or part of a software program that you've developed, then the whole of that software product is potentially licensed under the GPL v2. Now, the consequence of that is that you have to provide the open source. You have to make the source code open to anybody that you, if you develop the code, you have to make the base code available and your modifications available. You have to specify. Now, there are some instances where there are later versions of the GPL code which are more compatible with commercial purposes and actually making money from software, but it's something you really need to drill down into and check. And the best action that I can recommend that you take is to simply record from GitHub, wherever it is, the module that you've downloaded, how you've used it, and which license it applies. So it'll say potentially, it might give you an option of 2 licenses. It could be an option of GPL v2 if you want to be all for copyleft and trying to further the commons in general. And it could give you an option to use the MIT license, which is much more compatible with licensing commercially, making money out of it, and not having to disclose the full source code and thing that you've developed, which if you do that, then you're giving up the secret source, as it were. So, and a good example of this, if you want to look into it, is VM kernel. So that's something developed by VMware. It was proprietary, they say, kernel code, but it was based off of Linux. So there have been a raft of cases over the years of Linux developers using, which was licensed into GPL v2, using that as leveraged against big corporates who have used that code and really benefited their business and made a lot of profit out of it, but they've not shared that code with everybody else and helped to further the commons in general. So you do have these bodies which exist, which is the Free Software Foundation, that try and take these guys down and write angry letters and bring actions against them. And there was a guy called Christopher Helvig who brought an action against VMware in Germany, which I believe last year he dropped, but it wasn't necessarily settled. It was rejected by the lower courts in Germany because they believed that it appeared to be more of a shakedown, because there have been some GPL v2 shakedowns in the past. So shamelessly trying to take money out of large corporates for using Linux code, which is freely available to everybody. That wasn't the case in that matter. It was actually just trying to get VMware to make this kernel open source to everybody. So I wouldn't say that case being dismissed is indicative of that being some certainty. It's still up in the air, very much as to if you're using Linux code that's licensed under GPL v2. It is a business risk. It's something you need to take into account. And if you're providing software that's based on that license, you need to be bringing that risk up to your customers, because you don't want to be accepting liability for anything or having guaranteed that it's fine. So open source licenses can be very varied. I've mentioned a couple here, but there are hundreds, if not thousands, of open source licenses out there. Now, whether or not they are an open source license depends on whether or not you can get certified by a particular body. So there are organizations out there who you will submit an open source license to. There's recently been one for Chinese and English translated open source license code in order to try and bring China into the open source community. That is something which is relatively new and didn't exist before, so it was holding China back. That has, I believe, been approved now. But this is an example of a license which was rejected. But it's a good example of how you can have silly license conditions that you could not be aware of potentially in a license as part of the software you're providing. So let's take a look at the vaccine license, which is very on point right now. So open source, this is the prelude. Open source developers should work for good, not evil. Sounds fine so far. The misguided rejection of vaccination is one of the greatest evils that has ever existed. All right, maybe a little bit too far there. The vaccine license, the software licenser, requires that their users vaccinate their children themselves and basically require anyone that uses the software to be vaccinated in order to use the software. Now, obviously, it's a little silly. And on that basis, it's not really in line with people being free and unrestricted in using code. And on that basis, I think it was rejected. So don't worry, this license probably isn't going to apply to any software that you're licensing, or at least it's not been declared as a legit open source license. That doesn't mean that you might not sign up to this inadvertently in some way. So I think really this is a good example of the dangers that could exist in these open source licenses. And it's why you need to take it seriously and keep an inventory and check. And if you're in any doubt, then go and speak to a lawyer such as ourselves to look into it and read it and then tell you what the risks are, because they could be requiring you to vaccinate your entire family, neighbors, dog, whoever it is. So I'll hand you back to Paul to talk about the business intelligence company.
Yeah, so what happened with the business intelligence company? Well, they sold the business, the American company. They sold, basically they were a startup, sold for several $1 million, did very well, but we knew that at the completion meeting, which was taking place at some lawyers' offices in London, in the next room, there were other discussions going on as saying, in effect, are we going to complete this purchase or are we going to take these people down? So right to the last minute, that discussion was going on. We knew it was going on because the walls were very thin. We weren't supposed to know that. So that's what happened with that one. Yeah, okay. So I'm now going to pass it over to Tom and Virginia to talk about their area of work. So over to you. I was just finding the right place, I think. I think that's right.
So I'm supposed to have an option to take control of the slides.
Seamless handover.
Yes.
I think if you click the from current slide button in the top left, it probably will work. Touch wood, no guarantees.
No, because I don't think I've got control yet.
Just one moment,
Okay.
Do you want to just click through them, Paul, for me as I go?
Yeah, I think so.
I can just say next slide or something.
Just one moment. I'm just trying to do that. Just one moment.
It's okay, I got it. Go on.
You got it. Oh, right. Okay.
Who's got it? Sorry.
Martin's got it.
Martin's got it. Okay. Right. So, do you want to go on to the next slide? Just a brief introduction of Tom and myself. So, as Paul said, we're from Page White and Farrer, London-based. Opened an office in Leeds a little bit before lockdown, but as Paul said, we're now in lockdown. So I'm a European patent attorney. Tom also is a European patent attorney. European patent attorneys are rather strange animals in the sense that we have legal backgrounds and technical backgrounds. And our discussion today is going to focus on patent protection in software and tech. Next slide, please. Thank you. So as Paul mentioned, and it was actually the top of his list of potential IP rights for software companies, patents are a distinct right. They differ from copyrights and trademarks and design rights, and in some important ways. So what is a patent? A patent is a monopoly right over a technical invention which grants the owner an exclusive right to exploit the invention for a period of up to 20 years. And there's just a couple of things I want to point out of importance. A patent is a monopoly. It's very different from a copyright. In order to infringe a copyright, a potential infringer has to reproduce the software in question. That's not required for infringement of a patent. A patent is a true monopoly. So whether or not someone else has seen your software is irrelevant. If they end up with an invention, device, system, process, which falls within the scope of the patent will can be asserted over them. They don't have to have reproduced your actual software. So that makes it, in essence, a much more powerful right. And for that reason, patent protection is restricted to inventions with certain criteria that we will go into. It gives you a right to exploit the invention. And this also is important. It's a right, not a duty. So you don't have to exploit your patent. You don't have to use your patent to stop other people from doing things. And in fact, in these times, COVID times in particular, patents have a place for the use of good, like the open source licenses, in the sense that patent owners can decide who is going to use their patents. They can make it free for use to people who are doing good and restrict the use of other people who might want to use an invention for malpurposes. So that's important to understand. Patents can exist for up to 20 years, but they don't automatically sit there for 20 years. It's up to the owners to decide whether or not to renew their rights in that period. And in the field of software, Generally, patents would last maybe 5 to 10 years, something of that order, because by then the software has moved on and the fundamental inventive concepts will have substantially changed in the marketplace. So you only need to renew your patent for as long as it's valuable. Most of you out there will have seen patent pending. Patent pending doesn't mean patent. There's a process between applying for a patent and actually getting a monopoly right granted to you. And actually, Tom will talk a little bit about that process towards the end of our part here. But patent pending is an interesting notification which warns people that you have applied for a patent. The correct way to use it is to put in a number, patent pending number so-and-so or patent application number so-and-so. When you apply for a patent, you get an official number which you can use to mark your website, your products, your services, and that's an indicator to the marketplace that you are en route to obtaining patent rights. And that in itself can be an effective deterrent to third parties, to take eating your cheese. Next slide, please. So as I said, in order to get a patent, it is a powerful right. You have to satisfy certain criteria. And I put a summary headline there. The legal test to get a patent is new and inventive, patentable subject matter. So new is, at one level, an easy test. Has it been made available to the public before? Has it been disclosed to anyone not bound by fetters of confidentiality, or called a duty of confidence? That could have been by sale, it could be because you put it up on your website. And note that you can destroy the novelty in your own invention. So if you, even if you're the owner or the inventor, have put the product up onto your website before you've applied for a patent, it no longer satisfies the test of being new. And that's an important takeaway. The second criteria there is inventive. Now, the test of inventiveness is applied throughout the world in slightly different ways in different patent offices. However, I've summarized there a kind of global understanding of the test, as you might explain it. Something's inventive if it's not obvious to someone reasonably skilled in the art. And you might say, well, that doesn't get me much further, because actually what's obvious and what's reasonably skilled in the art. And we will come on to a couple of those definitions in just a moment. Next slide, please. So you will have seen in that earlier slide, I said new and inventive patentable subject matter. And that was a bit of a circular argument, right? Because I'm saying that something can only be patented if it is patentable. But what I mean by patentable is this defines a set of legal criteria. And the most effective way to explain this during the context of software is to explain what's not patentable. I've extracted here a section from the Patents Act in the UK. But actually this law is similarly worded across Europe and has very similar parallels in patent offices throughout the world, including US, Japan, China, and some key territories. So in learning how the UK law works, you can sort of understand the way the patent offices are viewing what is patentable. Of importance, they don't consider a mathematical method to be patentable. They don't consider a program for a computer to be patentable, and they don't consider presentation for information to be patentable. But before you all go home, or Paul says, why have I got Paige White and Farah talking about patents here? The law also says it won't apply to any of those things as such. And in those two little words enshrined in the law is a huge entry point for thousands and thousands of software patents. And we're going to give you a little bit of an insight into how those exclusions actually apply in practice. And I think at this point, I'm going to hand over to Tom to give you a little bit more detailed information about these exclusions. So that's next slide. Thanks, Martin.
So we've looked at what's not a patent. Well, really, the fundamental requirement is you have something. So I've got a note saying my audio. So I'm going to move a bit closer. It looks are having some issues with the audio. Any piece of how is that?
That's better.
That's better, Tom.
Looks like it was a problem. So we looked at what's not a invention, but what is. And essentially anything that is actually solving something the patent office So to give you a few examples, we've simply got an algorithm.
Your audio is still not great, actually, Tom.
Okay. How is that?
Yeah.
Sorry, got a very large head now because I've moved closer to the
That's better.
screen. So essentially, if you've got an algorithm that's operating on arbitrary numbers, and that's the level that you're that's going to be regarded as an abstract piece of software. It's not anything.
It's still not good enough really to understand. Shall I carry on with the slides, or do you want to have one more go at audio?
Yeah, you carry on and I'll see if there's anything I can do in the background.
Okay, super. All right. So, Martin, could you go back to that slide, please? Thank you. So we looked at what isn't patentable. So what is patentable? So what is patentable is a product or process or system which solves a technical problem. And this can in fact be software as long as the software is performing a non-abstract function. And that's where we get into that legal language as such. And the patent offices have construed this to allow technical applications and technical implementations of any of these excluded materials. Now that includes mathematical methods, it includes computer programs, and it includes presentation of information. So all of those things can be patented, provided that you can put them into a context which is technical. And I just note here, because it's so relevant nowadays, that machine learning models, AI, are being treated by most patent offices under the guidance for mathematical methods. And we'll come on to that a little bit later. Next slide, please, Martin. So here are some particular concrete examples of things which the patent offices have decided are actually technical. And this is taken straight from the guidelines at the European Patent Office, in fact. So things like compressing video or encrypting electronic communications, although really software as such, if you like, have been considered as technical applications of that software. Anything which relates to the specific internal functioning of a computer, again, certainly software, is considered to be technical. So things which actually affect the internal operation of the computer itself, like security measures for protecting boot code integrity is one explicit example. Countermeasures against power analysis attacks, network management. There's a whole host of specific examples. And really the point here is to not try and make your own mind up about what might be technical and non-abstract. This is law that has developed over the last 10, 15 years and has been enshrined in the Patent Office guidelines. Next slide, please.
I'll try jumping in as I've switched to a headset. Is that any better?
It is better. Off you go, Tom.
Super. So yeah, thanks, Virginia. Just picking up on where Virginia left off, particularly around machine learning. Nowadays, it's interesting to see how some of this early case law that has led to conclusions that things like image processing, image distortion are technical, have fed into what are now considered technical applications of machine learning methods. So if you have a machine learning model, the model per se might not be regarded as technical because it's an abstract mathematical model and an abstract computer program when you implement it. But if you're training that model to do some practical task like image processing, image classification, image recognition, learning to extract features, then that's now into the realms of patentable technical applications. And actually the novelty might not be in the model itself, it could be in the way you train the model, or even in the way that you prepare the training set for it. And any of that can actually give rise to a patentable invention because you're now within the realms of a technical application. Similarly, an abstract machine learning model that has sort of general benefits, if you're architecting that model for tailored to a particular computing architecture, which could be your hardware architecture or software architecture, that again could get you into the realms of a technical implementation of what would otherwise be an abstract mathematical model, and therefore something patentable. There's another class of inventions that has sort of arisen around the idea of making a computer function better as a computer. So if we look here at some low-level examples, controlling the internal functioning or operation of a computer, load balancing, compilers to give you better quality code, these are all examples of areas where you are actually making a better computer. Now, if you'd made a better computer by designing a new hardware processor architecture, there's no question that you're into a technical patentable invention if it's new and non-obvious. But actually, if you're getting similar kind of benefits from something that's going on in the software, the courts and patent offices have been pretty pragmatic about recognizing that that's neither here nor there, whether it's software, hardware. To the extent it's software, it's not software as such, and it's patentable if it meets the other requirements. And if we could go to the next slide, this doesn't solely relate to the kind of lowest levels of your software stacks. HTC and Apple was an interesting case considered by the appeal court in the UK a few years ago. And this was looking at the multi-touch API that was provided as a way to allow developers to code apps with multi-touch interactions. And what you see here is that even though that's in some ways a sort of higher level component going up, actually that is making it a better computer in the sense of a computer that is easier to program, which clearly has a technical nature the court recognized and gets you into the patentability. So we've got an interesting question there in the thread about machine learning. So for machine learning as an example, would you be infringing if some aspect of your model has been patented as part of a different patent? I'm thinking of image classification where your system is doing something specific, but someone has a patent on image classification. So that's a really interesting question actually around what does a patent let you do, what doesn't it do, and what can and can't you do, and what can you stop others doing? So if it's okay, I will actually return to this at the end of this deck because that will fit into example I'm going to discuss later. So looking again, actually another really interesting area, particularly in the kind of app developing world generally, is user interfaces. So there's a body of case law that's developed in Europe that indicates that actually interactive user interface features, not simply presenting information to users, where you might be in the realms of that exclusion on presentation of information as such, where you're actually allowing the user to interact with the computer, provide inputs, get sensible outputs, you're into the realms of patentability and technical applications, technical problems being solved. In the context of apps specifically, you have specific technical challenges, for instance, around the fact that it's a constrained display, that you want to be able to do gesture multi-touch in a kind of intuitive way. There was an interesting hearing case in the UK last year, or maybe the year before actually, about a thermostat, and a thermostat that essentially used kind of smart technology to predict what settings the user might want to do, given the climate, time of year, whatever. And that was seen as a technical application of the computer program running in the thermostat because it reduced the number of clicks that the user had to go through to get to the desired setting. Next slide, please. Similarly, data structures actually are another really interesting area. So Paul's touched a little bit on database rights, which might be a time when the act of structuring data would lead to some form of protection around that. But actually, if the way you structure your data is solving ultimately some technical problem, if the way that you're using that data is facilitated by the way that you've structured it, then actually the structuring of the data itself could be a patentable invention to the extent that it allows the computer to perform better as a result of the way the data is structured. And again, coming back to machine learning, AI, this potentially applies to the way that you build your training set, your intermediate features, all of these things. You're kind of tied into your neural net architecture is largely down to how you structure that data. If it's giving you concrete improvements, this is all potentially areas that you could get protection. And actually, if you're into the realms of structuring your data in a way that takes into account the internal functioning of the computer to give you greater efficiency, memory benefits, performance, potentially that's into the realms when you could actually protect models per se. Something that's interesting as well about UIs, and to the extent they're customer-facing APIs, is actually an infringement. So if a competitor builds an infringing UI or an infringing API that they're offering to customers, it's potentially quite easy to then determine if they're infringing your patent or not. You don't need to have access to the kind of black box inner workings of their back end. So I'm going to hand back to Virginia at this point just to talk a little bit more about how the notion of obviousness and technical problem is considered in European patent law.
Thanks, Tom. So you will recall, again, going back a few slides, we ran through a number of criteria: new, obvious, and patentable. And what we've been really focusing on there is the patentable side of it. Patentable equaling technical, if you've been following Tom's explanations. So now we look at how do we assess obviousness. And this is done at the European Patent Office according to something called a problem solution approach. And although this approach isn't used worldwide, the general concepts of this are actually now being applied at most patent offices, although perhaps in a slightly less formalistic way. So the idea is you look at your invention, which is your product, your process, your system, what your software is doing, and you decide what features actually did render it distinct from the closest prior art. Prior art is in inverted commas there. I wouldn't worry too much about that. It's a piece of jargon, and it just means all of the published documentation that was there before your invention. So anything that came up in searches by the patent office, anything that you knew about. And generally, what you think makes your invention novel is what makes it novel. I mean, our experience of dealing in high-end tech with software companies is that you know what's out there already, and that you generally have a good feel for these features. You look at whether these features produce a technical effect, and these technical effects are the kind of things that Tom's been talking about. And then you look to see, okay, working backwards, a bit hypothetical, what technical problem is being solved by these technical features? And then you look to see, okay, is the solution to that problem obvious or not? And although this all seems a bit circular, in fact, what it boils down to is actually quite fundamental to the assessment that's made by patent offices. Is there a technical problem? Not a business problem. So this is not something solving a financial problem, for example, or a human resources problem, but something which is a technical, hardware, software, computer related issue. Concrete physical issue. If it is, then you've really just got to assess whether your solution was obvious or not. And the answer to that is to consider what a person skilled in the art might make of it. Next slide, please. So the person skilled in the art is a hypothetical being. And the most important thing for you to understand as entrepreneurs, innovators, inventors, software developers is it's not you. You are not people of ordinary skill in the art. You are people who operate in a particular context with particular information focused on the problems that you're solving. This means that you are in a very poor position to judge whether or not the development that you've just made in your software is obvious. It's a hypothetical assessment of obviousness that's made by the patent offices, because the person of ordinary skill in the art is a hypothetical being. And I can tell you how hypothetical he is by looking at the third line on that slide. He's supposed to have knowledge of the closest prior art to your invention. So he's supposed to know a number of documents that actually nobody apart from a searcher at a patent office would have put together before. And then you're supposed to assess, hypothetically, what he would have done with those documents without the benefit of hindsight of your invention. So all of these things are things which really only skilled examiners at the patent offices and patent attorneys can do, because you need a lot of years of experience in evaluating how these things are judged. So it's really important that you don't look at your own software, your own development, and think, well, it must have been obvious. It was really easy for me, and therefore it's an obvious invention. Next slide, please. Another important aspect of obviousness is, having worked out that the person skilled in the art is a hypothetical beast, and anyway not you, what is the test for obviousness? And it's certainly not what a layman might consider. Now, there's two examples here that have got nothing to do with software, but they're just to give you an insight into how the courts regard obviousness. And the wording to hang on to here is what would follow plainly or logically from what's already known. And those are very key words. Were there signposts in what was already known to the answer that you've now presented, to the solution that you've come up with? In Dyson versus Hoover, Dyson was using cyclone technology to make a bagless Hoover, a bagless vacuum cleaner, actually. Paul will tell me I'm wrong to use the word Hoover when he starts talking about trademarks. Anyway, the entire art of vacuum cleaners used bags. Dyson took well-known cyclone technology, and actually it was acknowledged that it was well-known cyclone technology. He didn't try and pretend it wasn't, but nobody in the art of vacuum cleaners had tried to make bagless ones before. So the court considered it not to be obvious and said, okay, that patent is good. In Haberman versus Jackal, it was an even more basic piece of kit. It was a child's drinking cup, and they had developed a slip valve in the drinking cup. Now, slip valves were known, drinking cups were known, but actually no one had thought of that, and children's drinking cups had been around for a long time, but of course they spilt, and this was solving the problem of spillage. So again, the court said, yeah, that wasn't obvious. It didn't follow plainly or logically from what had gone before. Somebody had to have an inventive thought. That patent was held to be valid. Now, I'm just going to hand back to Tom at this point to talk about a few more examples in the arena of software, which are a bit more relevant to you. Tom, you're on mute.
Thanks, Virginia. Yeah, I'll keep this quick as I know we're running a little behind now. So it's sort of just going back to some of the stuff I was talking about software earlier. If you sort of seeing the kind of examples we were talking about, you might have kind of picked up on a trend of us talking about fairly low level stuff going on down at the bottom of the kind of stack, or in terms of kind of low level image features, edge recognition, things like detecting signal characteristics. And in terms of looking for technical problems, non-obvious solutions, it's probably fair to say that there is a bit more skepticism from the Patent Office about higher level stuff, application level, but it's not a hard and fast red line by any means. So a couple of examples here are recently allowed cases in the European Patent Office. The first one was around taking user interface with a field, take feedback from a user and use that to discard certain classifications in a sort of iterative round of predictive suggestions by a text classifier. And that was considered a technical application of the underlying abstract models. Similarly, a medical billing scheme where it wasn't, you had a text classifier that was extracting a billing code and a confidence rating, but because it was then providing this to an API to then determine if a query needed to be passed to a clinician, that was now beyond the realms of abstract data processing into technical applications. Next slide, please. So a few more examples here. A video communication app developed in the context of online dating, where you'd start a video call between strangers with obfuscated video, and you had a gesture mechanism for controlling when those users wanted to deactivate that obfuscation, solving a technical problem around how you actually facilitate video communication events between users who don't know each other initially and might be a bit wary of each other. Similarly on data structures, so we didn't call this out specifically, but another of the statutory exclusions on patentability is game rules, but actually a novel data structure that lets you implement variable game physics for objects in a mobile gaming app is into the realms of patentable subject matter. Equally, embedding a payment token within a digital identity verification system that allows a user to assert and prove that their identity is what they say it is in a verifiable way and facilitate a simultaneous payment, again, into the patentable realms of patentable subject matter, even though there's restrictions around business methods. And if we go to the next slide, the final point I was going to make is just hijacking Paul's business intelligence company example. So something to consider here is that in that particular context, the company didn't have the right to commercially exploit the API. They built an application that ran on top of it and had clearly put some innovation into that, but they didn't actually have a right to exploit it because of the API issues. It wouldn't have stopped them from patenting it. So picking up on Arshad's question in the chat, you can come up with a piece of innovation. It might infringe someone else's patent. It might infringe their API rights, copyrights. It doesn't stop you from patenting it. It doesn't mean that you can use it. A patent doesn't give you freedom to use the thing you've come up with. But what it does do is stop anyone else from using your extra piece of innovation. So let's say they had come up with something patentable and patented it. It's something the big company liked the look of. You could have then been in a negotiation where on the one side, you know they like your technology. You know, in that particular circumstance, there was clearly plenty of other stuff to get the company over the line. But another potential useful negotiating chip could be, well, if you want to use this, you're going to need a license. We can't use your API, but you can't use our application because we've patented it. So let's talk. And that's essentially a classic cross-licensing scenario. And a big part of patents for startups and scale-ups is to be able to level the playing field in those kind of conversations. Another really common place where this comes up is where you have a startup or scale-up who is providing services to customers, and their customers are the big companies. Data analytics is a really good example. So there are so many innovative data science companies, startups out there with really specialist expertise in a particular area who are then providing services to possibly the tech giants, OEMs, you know, for vehicle analytics, that kind of thing. There will come a point after a few years where the CTO at one of these other big companies decides, well, we've learned quite a lot from you. I think, you know, thanks, but I think we're ready to take this in-house now. So thanks and goodbye. Again, there's going to be an awful lot of considerations in that discussion when you're trying to persuade them that actually that's not going to save them money and is not a very good idea. Having a patent in your back pocket that means actually they can't do this without a license from you is a useful tool to have. So the final point is just a note on process, just because sometimes we get questions on this. Patents are national rights, but you don't have to go off applying internationally for patents in every country immediately. There's some very efficient international systems that let you just file one patent application in a single country. And then you've got essentially a 12-month period before you actually have to start making difficult decisions about individual countries. So Chris has asked, are there any rules as to when you can apply for a patent in a software product lifecycle, e.g. if it's already in use? Can you apply for a patent a few months down the line? Excellent question. So just coming at the other piece of that, you can apply for it probably much earlier than you think. So you don't have to have coded it. In fact, provided you can get to a point when you've got enough to know around how this system or process is going to work, how the architecture is, that you can kind of sketch out a sensible block diagram on a whiteboard and explain it to us, that's probably enough detail. And we can write up a technical description that meets the requirements of the Patent Office on the basis of that. And that could be a long time before you've actually written any code, and certainly long before you have a working product. At the other end of the spectrum, it comes back to actually what Virginia was talking about earlier. So if you've released your product, and let's say the innovation is in the UI, and anyone with access to your UI can see exactly how your invention works because it's a UI feature, that's now entered the public domain. It's no longer new by the standards of patent law, and you can't patent it anymore because you were the one who put it into the public domain and stopped it being new. If it's something that's running on your back end, that's a kind of black box, no one could possibly know what's going on in there, you're completely free to patent that, even though you could have been using it for months or years, because you haven't put the information about how it works into the public domain. There's a separate question of what the value of that patent might be if similarly you couldn't possibly tell if anyone was infringing it. So the real takeaway is to really think about doing this earlier and to have that conversation early. And the kind of questions we'll be asking you is, well, what are the kind of technical problems you're solving? And if you have an answer to that, chances are you have a patentable invention. And the sooner you can file something on it, the better.
I think that brings us on to a question that was asked earlier by Lawless Creatives, who have just thrown in another one. But going back to their original question, does this apply to making an application? I think in the context of when do these rights arise, when it comes to software and copyright in particular, it could be when you're literally writing down or sketching the framework for an architecture for a new system or whatever it is, or for how a certain piece of software is going to work. You could be scribbling down on a napkin. It could be just the idea. It doesn't necessarily have to involve any code or brackets or anything of that nature at this point, but you may have already created copyright effectively in that idea. So that's something to always consider, is what do you have to prove when you've created something? Go back to that diary of notes that you've created a little while ago and share it with your lawyers, because that could be something which indicates that you've got it first and they've copied from that or whatever it is. Paul, you're going to answer the other one from Lawless.
Yeah, that's right. So there's a question here from Lawless. So so they've got a historical app they're making. When he talks to the university, wants to help us. So in terms of protecting the idea when you're in talks, you need to once you disclose something, you lose the protection unless you've covered it by confidentiality agreements. So you need to have very clear confidentiality agreements in place to make sure that you don't lose the protection that you would otherwise have. So good NDAs as far as that's concerned, and that's obviously something we can help with. If you've got questions, carry on putting them on the Q&A, and we'll try and deal with them either as we go along or when we get to the end. So thanks, Tom and Virginia, for that section, which is fascinating, absolutely fascinating stuff, and I think real value to tech businesses that are on this webinar. So we'll continue looking at, just make sure I've got this. Oh, sorry, I've just done the wrong thing. Are you still on there, Martin? Right, sorry, I've just done something terrible, I think. We'll just get this back on. We're going to be talking about trademarks. Just one moment. Yeah. So trademarks. Trademarks are another entirely different type of right, but they're really important in terms of adding value to your business. So this isn't about the product, if you like. It's about the name, the branding, and so on. And we're going to give some examples. Trademarks always give a good story because they tend to be about things that you know about. So a trademark is registrable. It requires an original word or graphical representation. It can be a logo, it can be sign, a symbol, a name. It can be shapes, colors, and smells, although they're more difficult to achieve. So it's a mark of origin, and you'll see the kind of things that really matter. So it needs to be original. A trademark needs to be not just descriptive. So if you, for instance, have something that's protective clothing, so if you call it Leeds protective clothing, you're not going to get that because it just describes what it is, but also it doesn't work if it's purely geographical. Having a bit of trouble moving on this. Yeah, so if it's just a geographical description, then that's not going to work either. So trademarks, you trademark something at the Intellectual Property Office. It's national. So you just go back. So you trademark the Intellectual Property Office within a certain number of classifications. There are 45 classifications. So one might be food, one might be software, and so on. So at an early time with your business, before the name is known and before the logo is known and so on, if you get this registered, it gives you a lot of protection. It must be for an intended use or an actual use. And if you've trademarked in the UK currently, you can also carry that over to an EU mark. It's going to get more complicated come the end of the year. Because EU marks will transfer across as UK marks, but not the other way around. It's really inexpensive. So to trademark, to apply for a trademark costs £170 for an online application. £170 gives you 10 years of protection, and it's renewable forever after that. So rather than just the 20 years you get with a patent, or even the 70 years you get with copyright, trademark can be renewed for a huge long time. Next slide, please. So the oldest trademark is this one. So for Bass, they trademarked this in 1875. And still it goes on. That red triangle for Bass beers keeps going on. So they've had terrific value from that. So even for startup business that's bootstrapping, not too much difficulty with that. Another example is, and this has been subject of massive litigation, chocolate in trademarks is a big story. So as between Nestle and the people who bought Cadbury's, who originally were Kraft, litigation goes on tit for tat. So trademarks the colour purple, Cadbury's tried to register in relation to chocolate. That got knocked back, that got appealed against. So far they've lost on that. And then the other way around, you had, oh, we just lost that. Anyway, we'll come back to that, but over the shape of a Kit Kat, we had, there was similar litigation the other way around. So we'll just move on to the next one. So we have some musical interlude. So this should work. So this is music from the 1960s. No, didn't quite work. I'll just tell you what that's about if we can't get it working. Anyway, the story here is a 1960s band called the Bonzo Dog Doodah Band. Very wacky stuff. So if you get a chance to hear them or anything, you'll enjoy it. Anyway, they disbanded in about 1970. As happened, they then got back together. They've continued doing things since. And there was a company called the Anglo-Atlantic Media, who in 2015 they'd done some work with the remnants of the band. They registered the name of the band as a trademark. So it wasn't the band registered their name as a trademark, it was this other company. The band applied to the Intellectual Property Office to invalidate that because it wasn't them. They were successful, and then Anglo-Atlantic then appealed to the High Court against that. So for the band members who this had been their life, they were pretty upset about this, to be dragged through litigation, the cost and so on of that. But eventually they did secure the rights to their name, but caused a huge amount of upset, huge amount of cost for something that was theirs originally. So by not, when they were kind of young and carefree, if you like, not protecting that name, then many years down the line, they had a battle over it, which has caused a lot of difficulties. Next, please. So yeah, I mentioned Kit Kat. So again, Nestle, who now own Kit Kat, and they've tried to register the shape of a four-finger Kit Kat, specifically a four-finger Kit Kat, as a trademark. They were unsuccessful in that currently, but again, that's part of the chocolate wars going on. Next, again, Apple. So you thought that Apple computers would own all rights. Of course, when Apple computers started, they never thought that they were in the music business, they were in the computer business. Apple Records was originally the offspring of the Beatles. They did at one point have an agreement between themselves to make sure that they didn't infringe each other, but as iTunes came along and Apple became a major music purveyor, then again potential litigation between the Beatles record company and the computer. So they eventually reached a settlement as to how that would work. But you can see how registering trademark in categories that you might move into is pretty important and potentially valuable. Next, please. So what happened with the Tour de France campsite? Well, the issue only came up in the week before the tour came to Yorkshire. The tour people wanted tens of thousands of pounds for the right, but time was running out. Eventually a settlement was reached, a small amount was paid, but people like Tour de France, Olympics, FIFA World Cup and so on, they have hugely valuable trademarks and they will defend those. So coming across people with value of that sort, you need to be very careful. So what happened also the next one? So yeah, come on to that. So what was the problem with the care business that I talked about, domiciliary care business? Well, the problem was that the product had been written by a third party, a contractor. Therefore, whereas you would expect, okay, it had been written for the care business, therefore it was theirs, that's not actually the case, not in UK and EU law. It hadn't been assigned into ownership of the care business, and therefore what happened was that the contractor who'd written it, they claimed ownership of it. This was a problem because we were in the course of selling that business, and suddenly it was an issue whether we owned that core element. So you always need to be careful to make sure there's a contract in place with contractors to make sure that you, the business, own the software. If the development's been done by employees, then it does belong to the business. But watch out for contractors, by intellectual property rights being owned by founders in their own name, or by someone who was helping out casually, which might be the case with, for instance, some work being done on a website or something of that sort. Next, please. So yeah, so beware of unintended consequences. So with the care company, literally what happened was we were on our way to a meeting about the sale, and I received a text from the people who've written software saying, yeah, we will assign it to you. We want £1 million for this. Literally £1 million is what they wanted. And that wasn't going to happen. The business wasn't going to be sold for a huge amount more than that. Eventually, we had to sort of come clean to the owners, come clean to the buyers, and they said, you know what, we've got our own rotor software. We will implement our own rotor software, so we're not going to be using that. So actually, it doesn't particularly have value. There are other things that we're buying the business for. So we were able to bypass that, and the people who thought they were going to get £1 million got nothing. Quite right too. Next, please. So what isn't IP? So domain names. Often people think we've got the domain name and therefore we own this, or even the company name, we've got that and therefore we own this. So these kind of things are not IP. People's own names. Just because you're called McDonald doesn't mean you can call your burger company McDonald's. So be aware of things which are not going to work. But if you're aware of IP, you'll see it's all around you. So in certain products, there are different layers of IP. So I mentioned games, so or a record or something like that. There's music, there's performers, there's film, books, games. So you need to be able to prove the origin of the IP, particularly where it's something that that isn't registered. With a patent, it's simpler. With a trademark, it's simpler. But with copyright, you need to be able to take steps to prove the origin. There's obviously value, terrific value in IP, so you need to make sure that you protect the IP that you've got. Okay, I think that we are just about there. So I'm sure that you'll see that from what we've done that there's core business, there's core value in the IP that you have. Okay, we've got another question on trademark. This is again from Lawless Creatives, I think. So I'll take that one, and then I think there's something from Chris about patents. So can you trademark the logo for your design idea? Quite possibly. Again, you need to understand what it is you're trademarking, that there isn't someone who's got similar trademark. A really good point that Tom made earlier, actually, about level playing fields. So if you've registered a trademark, and the same is the case for other intellectual property rights that are registrable. So you might be a small business in Skipton, for instance, or something, but if you registered a trademark, then that is valid against anybody else in the UK. If you register it in other jurisdictions in the EU, for instance, then it's valid against anybody in that area as well. So whereas you might be using a mark locally, if it's not registered, then it only protects you against people who would know about you in your locality. Trademark registration gives you a much bigger capability and bigger protection, so nationally. So you need to look at what the exact circumstances are. Tom or Victoria, I think there's a question from Chris. Who we
Yeah, this is that question.
I think Tom, I think if it's the question I'm thinking about, I think Tom was responding to that earlier when so Chris Willis's question, for the benefit of everybody, is, are there any rules as to when you can apply for a patent in a software product life cycle? E.g., if it's already in use, can you apply for a patent a few months down the road? And that was where I think Tom was explaining it sort of depends on what the product is and whether that use has made the product available to the public. So whether your invention can be seen when the product was in use. If the answer to that question is yes, then no, you can't protect the product down the road. If the answer to that question is no, then yes, you might be able to protect the product somewhere in its life cycle. So have a chat with us.
And just to add one nuance, that even if it is out in the public, actually, if it's less than a year ago, some countries will still let you patent it, including the United States.
Yeah, I think one final point, just as a practical note, because it's come up, and how do I protect my IP early, and what are simple things that you can do which are cost effective. I mean, you've mentioned trademarks as being very cost effective and providing a lot of value, but if you're developing code in particular, what you'll find is that you have to reproduce certain copyright notices. So for open source licenses, you have to say the next bit of code that you're about to see is subject to this open source license, whatever it is. So what you might want to do is create your own copyright notice and embed that within your code, either dead brackets, developer's notes, somewhere it's not going to mess up the operation of the software that you've developed. But further to that, don't just use one form of copyright notice, because I could easily do a Control F, replace all, find each mention of your copyright notice and delete it and replace it with 0 or whatever it is. So have a couple of different forms of copyright notice to trip people up, because they'll have some reassurance that they've seen your copyright notice at the very start of your code, and they can just delete that and delete any reference to it within the lines of code that you've provided to them. If you've got a little cheeky dead brackets, developer's notes, Sam was here 2020, something as simple as that can be very valuable if you end up in a dispute later and you get access to source code and you find this little signature that you've left in the code which is pretty much hidden and doesn't do anything and very hard to spot, then that's a very practical and free way of ensuring that you've got some protection there. It's worth considering.
Good. Chris has got another question about trademarking. So as far as trademark service is concerned, so we do essentially UK trademark. We don't get involved in trademarks wider than that. Tom, Victoria, are you able to say what you do on that?
Yeah, we provide a trademarks service in the UK and also overseas. I mean, I'd suggest in the first instance chat to Paul about the trademark coverage, and then if he thinks it needs to go wider than the UK, he can give us a shout.
Thank you. Sorry, a phone rang behind me. I think it's been picked up now. Yeah, so yes, we can certainly look at that in the first instance. I think that's probably the right kind of balance. So this is the one area where we have some overlap, but actually the way and the scope of what we do is probably distinct. But on the other areas, as you've heard, we've got quite distinctive areas there. Okay, I think that's all the questions that I can see, and I think we're about up to our time that we said. If anybody has any more questions, then by all means contact us directly. We're easy to find. I'm not sure if the contact points are on here, but we're easy to find anyway. We are physically based at Platform, but in this day and age, we're virtually all over the place, of course, and physically all over the place as well. It's been really good to work with you, Tom, and Virginia on this. Thanks again also to Bruntwood for their assistance with this. Thanks all of you for being on this webinar, and I hope you've found some useful stuff for you. Do contact us if you would like to take anything further forward. We're certainly happy just to have an exploratory chat. I'm sure that's the case for Tom and Virginia as well. Again, thank you very much. Enjoy the rest of your day. Thank you.
Thank you very much.
Thank you.